Okay, thank you, Catherine, and good morning, everyone, and congratulations on opting to come to work on a morning like this. What I'm going to be basically talking of is the legal effectiveness of terms and conditions which you find on a website. We all experience this every day. Sometimes you're required to click on OK in relation to certain terms and conditions. Sometimes you see them down the bottom in a toolbar saying terms of use or terms of service, something like that. Sometimes you don't see them at all, but in fact they're hidden away there somewhere. And for obvious reasons, it's of increasing relevance to know the extent, whether and to what extent these terms and conditions actually do bind a person who's using the service that the website offers. Now, as a practitioner, this is an issue that comes before me, I would say, literally once a week in one form or another. Typically, it might be a supplier, perhaps an overseas supplier, who is inquiring whether or not the terms and conditions that they attach to the product or service that they sell over their website are actually legally binding on the user. And why is this important to them? It's important because their whole global marketing strategy depends upon having consistent terms and conditions. And their whole business case depends on those terms and conditions validly incorporating things like a cap on their liability, a disclaimer of warranties, a dispute resolution clause that might involve arbitration, a governing law, maybe a venue where all disputes have to be heard. This is what the service providers are getting at when they formulate these terms and conditions and put them on their website. It also comes up regularly in another context, and that's in relation to privacy policies. It's increasingly common for companies to seek reassurance that their privacy policies that appear on the website and the little sort of toolbar down the bottom that no one ever reads, it's increasingly important to them that the privacy policy that's linked there is effective in eliciting enforceable and binding consent by a person who's using the website. And why is that? Because the terms and conditions, the privacy policy will talk about how that company is going to use personal information that they acquire from a user of the website. And it might say that they're going to do certain things that they can only do with the consent of the individual, like send the information, store the information overseas in certain jurisdictions, or use it for secondary purposes that are unrelated to the original purpose of collection. So that's why the issue is important, and it's why it comes up every day, because every business wants to know the answer.
Yes, Dr. Hughes, good morning, it's Harry. Do you find that the terms and conditions, irrespective of whether it's face-to-face negotiations or through an online interaction, are any different in policies at all?
In terms of, when you say face-to-face, do you mean a traditional contract versus an online contract?
Yes.
Not necessarily, although online terms and conditions are tending to deal with a certain type of transaction, so they're a little bit more focused perhaps. And sometimes the online terms and conditions aren't the whole contract. It's just they assume you're entering into a contract when you buy something through the website, but part of that contract will be this little disclaimer clause on the side saying, by the way, we don't accept any liability for anything that goes wrong, stuff like that. But I don't think it's necessarily the case that online terms and conditions are different to what you get if you're presented with a contract to sign. The thing about signing a contract, though, is you're more likely to ask questions and you're more likely to say, I want to delete this clause or that clause, which is where we're heading with this discussion. Okay, but fair question to start with. So this is where I'm going to go with this hour. I'm going to talk a bit about the terminology that the American courts have adopted, and you see it there: CLICKWRAP, BROWSEWRAP, and signing wrap. Awful American expressions, but they the judges tend to classify most of their cases into one of those categories. I'm going to mention, just in the space of one slide, the foundation pillars of contract law that are of relevance to this issue. Because as I'll explain to you, we haven't had many Australian cases of great significance or relevance in this area, whereas there have been hundreds in America. But there are some certain fundamental principles of Australian contract law that are over 100 years old, but are totally relevant to what we're talking about. Now, I'm going to go through and concentrate on these American cases, the CLICKWRAP, BROWSEWRAP and sign-in-wrap cases. Now, normally in Australia, we don't care much about what American courts say about many things, because simply the rules are so different under American jurisprudence than what they are in Australia. But this is an area where I believe Australian courts may well be influenced by the approach adopted by American courts. Partly the reason is that the fundamental principles are essentially the same. And secondly, what's really of relevance about these American cases is the process they adopt in analysing the facts and working out how those facts should be interpreted in light of these fundamental contractual principles, which are fundamentally the same as Australia's. I'm then going to touch on 3 cases in Australia, the only 3 I can find, where the question of whether or not an online contract is enforceable has been discussed. I'm paying those a little bit of lip service because, in fact, the discussion has been very cursory and is not terribly enlightening for our purposes. I'll then go on to this Uber case, MEYER and KALANICK. I don't want to overstate the significance of this case. It's not a case that's going to sort of go down in the lexicon of history as one of the all-time groundbreakers, but the judge does raise some very interesting issues which I think are worth talking about. It's certainly going to gain currency in American jurisprudence, and I think the issues that he raises may well filter over here eventually. And then finally, I can't leave this topic without mentioning the Australian consumer law, which introduces a few local rules that do tend to tighten up. Well, no, actually, it just influences the way we look at these cases. Okay, so that's where we go. Starting with this terminology, and I need to emphasise a couple of things. One is this terminology will never be adopted by an Australian court. It's pure American judicial slang, but it serves a sort of a purpose because it helps the courts and the parties basically focus on what sort of situation they're dealing with. Having said that, they're very fuzzy around the edges, and you'll find that some cases could fit into 1 or 2 or more of those categories. But essentially, this is what we're dealing with, 3 different types of cases. The CLICKWRAP cases are the ones that you're very familiar with, you deal with every day when you go online for something and you've got to click OK before you continue. Specifically, you're clicking OK, I agree with these terms and conditions, or do you agree with these terms and conditions, click OK, you click OK, and you go to the next screen. That's a CLICKWRAP contract. A BROWSEWRAP contract is sort of the opposite. There's terms and conditions somewhere there on the website, but you don't have to click on them in order to use the service. They might appear down the bottom in a barely legible toolbar down the bottom saying terms of use, conditions of contract, whatever, or it might be in big prominent flashing lights on the first screen, terms of service. You make sure you read these if you want to know what our conditions are, or it might be buried away somewhere where you're never going to find. Wherever the terms are hidden, however they're displayed, if you don't have to click on them, that's a BROWSEWRAP. In other words, you browse the terms if you want it. And the third type of contract in this category is the so-called sign-in-wrap contract, a very ugly expression that's just been coined in the last 12 months by the American courts. And this is a hybrid of both, a combination of both the other two, where you go online and you click, but what you're clicking refers to registering to receive the service it doesn't specifically say, or doesn't necessarily say, you're registering to receive the service subject to the terms and conditions which you must read, and here they are. So you're clicking, but you're not necessarily clicking what you're clicking in a CLICKWRAP contract. You're clicking, yes, I agree to be an Uber customer, for example. So, as I say, fuzzy distinction, but that's the way the courts have categorised them. Now, before we look at some factual examples, we need to look at factual examples against a backdrop of what the relevant considerations are from an Australian legal perspective. And the 4 cases I've got up there are sort of fundamental pillars of Australian contract law in relation to the sort of issue that I'm dealing with. Not that any of them involve CLICKWRAP contracts, but the principles will apply. And if any case along the lines of the ones I'm talking about today were to come before an Australian court, at least one, maybe all of those cases will be cited. The most important one is the oldest one, the 1906 case involving the Balmain ferry. And if you use your imagination, you'll see where this is going and why it's relevant to what we're talking about whether or not online terms are enforceable. Don't worry, I'm not going to bore you with a lot of factual situations today, but I have to give you a brief overview of the facts here because it's relevant. Back in 1906, to catch a ferry, you had to pay your money to go through the turnstile. And next to the turnstile, before you paid your money, was a big sign saying, once you go onto the wharf, if you want to come back, you don't get a refund. The chap buys his ticket, goes onto the wharf, misses his ferry, wants to come back, they won't give him a refund. Some of us would have gone on with our lives. He went to the High Court. But anyway, and he said, well, it wasn't part of the contract, just some sign lying around there. And the court said, it is part of the contract because the sign was prominently displayed. It was right next to where you bought your ticket. You couldn't have missed it. You knew that part of the deal when you purchased your ferry ticket was that once you're on the wharf, there was no coming back. And that's all you need to know about that case for the time being. But that theory keeps recurring all the way through these online cases. Were the terms brought to your attention before you committed to the transaction? And the counterpoint of that case is the case of Thornton and Shoe Lane parking. Now, that's an English case, a Court of Appeal case from England, but it's been adopted many times by Australian courts and is regarded as part of Australian law. And this was sort of the reverse fact situation to Balmain Ferry. It's known as the car park case. The driver drives up to the car park, goes to the ticket machine, puts in his money, gets his ticket. And on the back of his ticket, there are conditions printed. It says, your use of this car park is subject to conditions that appear on signs on the wall. Needless to say, he fell over and hurt himself, wanted to sue. Needless to say, the sign said, enter at your own risk. The court held in that case, unlike the Balmain Ferry case, the court said in this case that those signs saying all care and no responsibility didn't form part of the contract because they were only brought to the attention of the car driver after he'd entered the contract. He entered the contract, he paid his money, he got his ticket, he was past the point of no return once he went past that automated ticket machine. And it's too late then, when the deal's done, to be told, oh, and by the way, there are other conditions that are attached to this contract you've just entered into. Too late. Equated again to online terms. It's one thing to be told before you buy your stuff off eBay or whatever it is. It's one thing to know what the rules are then. It's too late to be told after you've entered into whatever transaction you're entering into, to be told, oh, there's some other conditions here we haven't told you about. The other 2 cases, I won't bother with the facts, but I just want to mention what they stand for because it's important, again, in the context of online terms and their enforceability. Robinson-Miller Airlines and the Commission of Taxation stands for the proposition that's marked, I've got there in red font. Where you're dealing with a ticket situation, i.e. there's no negotiation, there's no signing, if someone's dispensing a ticket or issuing a ticket, you've got to make a reasonable effort to bring any exemption clause to the attention of the purchaser. The Americans do that by having capital letters, and every second paragraph in their contracts is in uppercase. We haven't adopted that convention, and it's just a question of fact in every case as to whether a reasonable effort has been made. But where there's no negotiation, as in an online ticket case, online terms case, Australian law says a reasonable effort must have been made to bring the existence of those terms to your attention. And finally, Toll and Alpha Farm stands for two important propositions, I guess. And again, think in terms of online terms. If a contract is signed, it doesn't matter. If you sign a contract, it doesn't matter whether or not you've read the terms. And this is hundreds of years old, this proposition in contract law. You're deemed to have read, understood and agreed the terms when you sign them. If you're dealing with an unsigned contract, such as a ticket sort of a case, then proof is required that those terms were brought to your attention. So a big difference between signing and not signing, but if you're signing, whatever that means, and that becomes relevant, if you're signing, you're deemed under Australian law to have read, understood and agreed. So, let's look at some of these American cases, and we'll start with the uncontroversial ones. The CLICKWRAP cases. No one has ever contested the proposition seriously before an American court or an Australian court that if you click on, that by clicking on terms and conditions, you are agreeing to those terms and conditions. Okay, it's pretty fundamental when you log on. Here's a disclaimer, do you agree with this? Click OK. No one argues that that's sufficient to denote your acceptance of those terms and conditions. But there are various shades of grey in that proposition. The early cases dealt with a pretty fundamental issue of what happens if those terms are really long and convoluted. And that was the case in Forrest and Verizon back in 2002, which was a District of Columbia Court of Appeals case. Basically there, the issue was that you had to scroll through 13 pages of terms on a scroll box before you got to the OK icon at the end. And bear in mind, this is 15 years ago, it seems like yesterday to me, but a lifetime to most people. Scroll boxes, this whole concept of online contracting was brand new, okay, 15 years ago. And the courts were a little bit challenged by the concept of not having an entire contract in your hands at one time where you could see the whole document as a self-embodied contract where you could flip through from page 1 to page 13. The court was rather challenged not just by the length of this contract, but by the fact you actually had to scroll. This was a new way of doing things. You couldn't see all pages at the same time. You couldn't see all of one page at the same time. Anyway, they worked through the process and came to what I think was the right answer at the time, and that was fundamental contract principles. You sign the contract. It doesn't matter how long it is. Doesn't matter whether you've read it. You're bound by it. The guy here had clicked OK. End of story. It didn't matter that it was 13 pages long. I emphasise that because it comes relevant later on. And then there's this case of DeJohn and .tv, and that's not a typo, the dot is meant to be before the TV. This was a similar sort of scenario, but the plaintiff in this case said, yeah, but look, it was really long. I'm not a lawyer, I don't understand these things. In fact, I didn't even bother to read it. It wasn't even worth me getting started. And Judge Manning from Illinois came out with one of these very American quotes which other judges love, and this gets quoted ad nauseum in judgments in America. The fact he didn't read the terms is irrelevant. failure to read a contract is not a get-out-of-jail-free card. Now, I don't know if the younger generation plays Monopoly, but us older generation thought that was absolutely hilarious. But anyway, it comes up regularly in judgment. So nothing terribly contentious there. What they're saying is an online contract where you scroll through, click OK at the end. It's just like signing another contract. Nothing new here. Let's move on. And then, but that was the old days where you would scroll through the contract and click OK at the end. We then moved into the era of space efficiency and hyperlinks. And no longer, and this will be the case, you'll all be aware, or in virtually every case now, you don't actually read the terms and conditions in front of you if you're entering into an online transaction. The expression terms of use or whatever will be hyperlinked through to the actual terms. The courts had a bit of fun about whether the hyperlink part of it was enforceable. They got over that. The issue with CLICKWRAP cases then became, are these terms nevertheless incorporated when the OK button doesn't appear physically at the foot of the terms and conditions? Courts felt very comfortable when you had to scroll through 13 pages to get to the end, as if you pick up a term on the way through and think about it. But where you didn't actually have to scroll through, but the OK button appears next to the hyperlink, is that good enough? And what the courts have held is that in the right circumstances, yes, but so long as you know what you're actually getting yourself in for. So in Wit and Prosper, which was a case before the District Court of the Southern District of New York, which comes up a lot, that court. It's a federal court, obviously located in New York. It's a federal court, but its status in the scheme of things is a bit like the status of a state Supreme Court in Australia, from one of the biggest states. So influential on a national scale, even though its jurisdiction might be well confined. Anyway, they dealt with the situation, the first time the courts had dealt with it, where the OK box wasn't actually attached to the terms but next to a hyperlink. And the court said, oh, that's fine, no problem with that because of the way it was done. The box had a sign in clear and bolded text saying, clicking the box below constitutes your acceptance of the agreement. And the agreement was hyperlinked, and you could go and read it if you wanted to. And the court said that was fine. It dismissed, this is just an aside, so you just turn your brain off for a second. The court dismissed as frivolous the alternative argument. The plaintiff said, well, okay, so click through to see the terms and conditions. He said, when I realised I had a problem, I went back 4 days later and tried to click on the terms, and I couldn't get through. The link wasn't working. And the court said, well, too bad, you've missed the boat. If you'd raised that point at the time, if you clicked at the time you're entering into the contract, rather than clicking OK, you clicked the hyperlink and you hadn't got through, and if you decided, I'm not going to take the risk, and you didn't go on with the transaction, that would have been one thing. But it's too late now, you entered the contract regardless without bothering to do any of that. You can't come back 4 days later and say, hey, actually the link doesn't work. So, still no dramas about enforceability, but there comes a point where the courts draw a line. And that point in the context of CLICKWRAP came in this case of Seguros, which was a United States Court of Appeals case, so we're getting up the hierarchy. This is a case where a guy subscribed to an online credit rating service. You'd feed it information, you'd give the service access to other information about yourself, and it would calculate your credit rating. And the site contained an I accept button, but what the sign attached to the site said was, attached to the button said, if you click I accept, you authorise us to access your personal information. What it didn't say was, and you agree to be bound by our terms and conditions. So it got the click part right, it got the sign right, but the sign didn't actually tell the whole story. And it was on that basis that the court held that that contract was unenforceable. Again, wonderful Americanese. What cinches the case for Seguros is the fact that the site actively misled the user. They thought they were clicking on for one purpose. In fact, it was more than that one purpose. The last sentence: no reasonable person would think that hidden within that disclosure was also the message that the same click constituted acceptance of the service agreement. So what's probably detecting here is CLICKWRAP cases are pretty straightforward. The answer is pretty straightforward. The only mistake you can make up to this point is that you don't make it clear what people are accepting when they click I accept. The other element, and this is the last thing I'm going to say about CLICKWRAP cases, because CLICKWRAPs aren't really contentious, is that an issue that constantly comes up is terms and conditions that are being regularly updated. And you see this all the time in online terms, and particularly in privacy policies that appear on websites. They'll say, this is how it is, but we reserve the right to update these terms and conditions from time to time. And the question that has arisen, and which arose in these two relatively recent cases, and this is where the current debate is sort of sitting, is are the terms and conditions enforceable in this online one-way environment, contracting environment, when the supplier is able to update them from time to time? Putting aside some issues with the Australian consumer law, which I'll get to, the court, well, basically the case is formed into two types of situation which this could arise. One is where, regardless of the fact that the terms have been updated, every time you go to the site, you still have to click on I accept for those terms each and every time. The other way it can arise is when you register for a service, like Amazon, which is the second case, and you register and agree to the terms and conditions when you first register, but then for subsequent transactions you don't have to repeat the process. Okay? Now, Bassett involved the first scenario where you had to click on every time you used the service. And the court said there's no drama there. Every time you every time you use the service, you click OK to agree to the terms and conditions. It's up to you whether you read them each time or not to see if they've changed or not. So the court was quite dismissive of that proposition, of the opposition to that clause, and they said this is fine, this contract is enforceable. I think there are limits to how far you can push that theory, but that's where the law stands at present in that regard. The Amazon case dealt with the other type of situation in which you click on once and you register, but the terms and conditions, which you don't have to look at again, are subject to change going forward. And in Nicosia and Amazon, the again New York District Court held that that was a valid and enforceable way of contracting, so long as it was clear in the initial contract that this was a likelihood, thereby placing the user on notice that they needed to check the terms and conditions every time they went online.
Can I ask how you personally feel about that decision?
I think it's wrong. Well, I think it's bad law because I think both of them are bad because in the case of Bassett Electronic Arts, you get a pattern of conduct so that we click on every time. If you're not told that the terms and conditions have changed recently, and they haven't changed theoretically the last 10 times you've checked them, and suddenly they've changed, I think there's an argument to say that without warning the user is misled into assuming that it's the same. Nicosia and Amazon, I don't like that because, well, pretty much for the same principle. That if you don't tell someone that rules have changed, even assuming that someone bothered to read them in the first place, and they're not told that it's changed, even though you know they're subject to change, then I think it's a bit dodgy. The Australian consumer law makes it harder to do that in Australia. It doesn't make it impossible, but I'll get to that eventually. But your question is, you're thinking in the right direction. And then, okay, so let's see with the CLICKWRAP cases. Nothing terribly controversial, although that last question raises an issue about whether it's good law in Australia. It's fairly clear law in America that they're going to be enforceable so long as the supplier makes half an effort to make it clear what people are actually agreeing to. Then we get these BROWSEWRAP cases. Remember, the BROWSEWRAP cases are the ones where you don't have to click on anything. The terms and conditions are there somewhere, but it's up to you to A, find them, and B, read them if you want to, but no one's going to make a fuss if you don't read them. You can still go ahead and do the transaction. Now, these cases are more problematic because you have to prove, and it's similar to that toll and alpha farm case that I mentioned before, you've got to prove that a person was aware that those terms and conditions existed. That's the basic test. And that's an evaluation, turns purely on the facts, and it can go either way. There are two landmark cases in America on this specific issue. Those are the two I've mentioned there, SPECT and Register. In SPECT, the contract was found unenforceable. In Register, it was found enforceable. They've been cited in probably 1,000 cases since in America. And one party, whoever's trying to say the contract's unenforceable, says, look, it's just like the facts in SPECT, and vice versa. If you're on the other side, it's just like the facts in Register. There's no right or wrong answer. In one sense, it's purely a case of interpreting the facts. But SPECT, for example, was a case where the user downloaded some software off the defendant's website and got upset when he found that the terms and conditions that apparently attached to this software allowed them to install a cookie on his computer. And so he said, we're not allowed to do this, that wasn't part of the contract. The terms and conditions didn't form, that allowed them to do that didn't form part of the contract. And the court agreed with him. They agreed with him because the process was that you went to the first page of the website and said, download your copy of the software for free or something. So you do that. The terms and conditions, there was no reference on the front page to the existence of terms and conditions. If he'd gone to the next page on the website, he would have found some terms and conditions. But there was no need for him to go that far. There was no need for him to, and certainly no requirement for him to agree to click on an OK, but he didn't even know they were there. If they'd been prominently displayed on the first page, it might have been different. But there was no logical reason why he had to go that next step. And that's what the quote there says, which you can read for yourselves. The court on the facts came to a different decision in Register and Vireo, another Court of Appeals decision, so very high up in the court hierarchy in the United States. But in this case, it was sort of similar in concept to the circumstances described in SPECT. The one difference was that the evidence was that the user, in this case, was a constant and regular visitor to that website. And the court said that changes the ballgame. Think in terms of the car park case, the Thornton car park case that we talked about before, where the guy didn't know the sign was inside when he had his accident. It wasn't brought to his attention until after he entered into the contract. That was fine the first time he went to the car park. But what if he'd been going to that car park for the last 12 months and seen that sign, parked underneath that sign every day? It could have been a different decision. He could well have been aware under those circumstances that that was part of the deal. And so what they said in Register was it was part of the deal. Maybe he would have missed it the first time, but he well knew, and there was evidence because the guy was a bit of an idiot. He bragged about the fact that he was a regular visitor and knew it, and knew about this condition. Some people are their own worst enemies. But anyway, so the court said, in that situation, where there's evidence that you knew about it, the contract can be enforceable. It's not simply a case of how it's brought to your attention or whether it's hidden or whether it's obscure or whether it's in your face. If there's evidence that you're aware of the condition, then that'll be part of the deal. The challenge is to find that evidence. Now, these two cases are those first two cases I said are the landmark cases in this area. The purpose of this slide is just to bring you up to date with a couple of more recent cases, although 10 years further on, to show that the issue keeps coming up and will always continue to keep coming up in America, at least, because they all turn on the facts, and the question is looking at the facts in each case and deciding, was reasonable notification given of the existence of these terms or not. The Van Tassel case was a rather familiar fact scenario where you acquire a product for a trial period for a certain price, but you can pull out after a month. But the small print in the terms and conditions said, no, actually, if we want to, we can keep on charging you on a monthly basis for the next 2 years, which is what happened. And so that's what the argument was about. The issue here was that on the home page, on the home page, yes, there was a reference, there was a link to the terms and conditions, but the name on the link, the name on the toolbar linking you to the terms and conditions, said customer service. It didn't say contract terms of use, it said customer service. And the argument that the court accepted in this case was that that wasn't sufficient notification of the existence of terms and conditions, because it didn't articulate clearly enough exactly what that hyperlink was all about. As you can see from the quote, it's unenforceable because the process required users without any reason to do so, i.e. no need to click in order to continue. Scroll down the home page, make the illogical leap that customer service means finding conditions of use behind that link. So, interesting decision, but that's what he decided, and it becomes relevant as we go down the track. Zappos was a variation on the same thing. The thing in Zappos, I won't get bogged down in the facts, the thing about Zappos was that there was a hyperlink on the front page to the conditions of contract, but it was one of about a dozen hyperlinks. You've seen those where you've got a whole menu of hyperlinks on the front page that you can click on for one reason or another. The court didn't like the way it was displayed and decided that it wasn't conspicuous enough, because remember, it'll only be enforceable if the user has been provided with adequate notice of the existence of those terms. It's the same under Australian law. I've given you one quote there: highly inconspicuous hyperlink buried amongst a sea of links doesn't provide adequate notice. And he went on to say, whereas here there is no acceptance by the plaintiffs, no meeting of the minds, no manifestation of assent, there is no contract. So that's where we are with BROWSEWRAPs. You've got more work to do with the BROWSEWRAP contract. You've got to show that it was brought to the attention of the person as a matter of fact, whereas with a CLICKWRAP, it's deemed to have been brought to the attention of the person by the fact that they've clicked OK. Now we get to these sign-in wrap cases. And remember, the sign-in wrap cases are the ones where you click on something like register here. It doesn't necessarily tell you that you're also agreeing to an extra set of terms and conditions that are somewhere to be found. It's generally recognised that the first of these so-called sign-in wrap cases was this Fataja and Facebook case, even though the expression, the awful expression, sign-in wrap wasn't coined for a couple more years after this. There's a typo on this, which if you've got hard copy, it's possibly the most critical typo of the lot. This should say terms of service, not terms of use, in the 5th line. I couldn't get to Catherine quick enough to change that one.
You can change on the fly.
Don't change it. Now, so this obviously involved a Facebook user who'd signed up, and Facebook, in accordance with the terms and conditions that apply, disabled his account for whatever reason. This was the worst thing that ever happened in the life of Mr. Fataja, and he claimed that this caused him emotional distress, hurt feelings, and a damaged reputation. And he complained that he clicked on sign up, and there was a reference to reference when you signed up that said make sure you read our terms of service. So that was good, but he says I went looking for them and couldn't find them. Yeah, there was something that said terms of use, but nowhere could I find terms of service. Courts hate arguments like this. They tend to regard the people making these arguments as smart asses, to be quite honest, because it's someone trying to be technical and it just doesn't work. And the judge absolutely hated this guy. As you can tell from this quote, it's not too much to expect that an internet user whose social networking was so prolific that losing Facebook access caused him mental anguish. Is it too much to expect that he would understand that the hyperlinked phrase terms of use actually means, and should say, terms of service? Whether he bothered to look at it is irrelevant, and so on. So that was sort of basically settings. That's just a factual example. It doesn't actually break a lot of new ground there, except to say that courts, at least in that case, won't be too much influenced by sort of technical arguments of that nature, pedantic arguments of that nature that really don't advance science of jurisprudence at all. The phrase sign-in wrap was then coined by Judge Jack Weinstein from New York, in this case of Berkson and Gogo. This was another case where someone bought a service and thought that their credit card would only be debited once, but kept on being debited month after month, and the terms and conditions said that Gogo could do that. The facts don't really matter. The important thing is that it was held to be an unenforceable arrangement, and the judge set out that 4-point summary of things to take into account. Is there evidence that the user was aware? Number 2, is the terms of use obviously available? Was the importance of those terms of use emphasised? And was the customer's attention drawn to the material terms? So that's now sort of regarded as sort of a checklist to be followed in the so-called sign-in wrap cases. I'm going to go on. The case of MEYER and KALANICK, which we're getting to, the Uber case, that is a sign-in wrap case, which is where we're heading. We're going to talk about that in a second, but before I talk about it, I want to pause and look at the Australian cases that have dealt with these online contracts that I've been talking about. And it's relevant because we know from what I've said so far where American law is heading and where it stands. I've told you what the pillars of Australian contract law are. To complete the current picture, I'll just mention these 3 cases very briefly, and then we'll look at what this Uber case said that challenges some of these fundamental propositions. In my view, none of these cases is very significant at all. I'm constantly being told by people that the eBay case is a definitive case in relation to the enforceability of online contracts in Australia. It's really not. It's a federal court decision. This involved the big day out. I don't know whether they still have the big day out, but I used to have young kids and they used to go to it. You could buy a ticket through Creative Festival Entertainment online to go to the big day out. And when you clicked on the terms and conditions when you bought the ticket, it said, we reserve the right to cancel this ticket if you resell it for profit. So in other words, if they detect a scalping syndicate in operation, they reserve the right to invalidate those tickets, to clamp down on the scalpers. Obviously, eBay immediately gets a little bit twitchy. But anyway, that's what you agreed to when you clicked on, that's fine. When the ticket turns up in the mail, or in this case, when it turned up in the mail 6 weeks later, the hard copy ticket, you had the conditions printed on the back, but they changed one of them. And effectively it said, this ticket is automatically invalid if on-sold. So they'd strengthened their restrictions on reselling the tickets. And so this caused an issue when someone tried to sell it on eBay. The question then became, was the contract formed when the purchaser clicked online, when the ticket was voidable but not invalid, or was the contract formed only when the ticket turned up with the hard copy terms saying this can't be on-sold? And the court held that the contract was formed at the time the user clicked OK. That's when there was a meeting of the minds. That's when the deal was done. Putting a different condition on the ticket when it turns up 6 weeks later is a bit like putting up the sign in the car park after you bought your ticket. Indeed, they quoted Thornton. The judge cited Thornton in that case. That's the car park case. That's actually all the case stands for, and I don't think, see, it doesn't start to go into the analysis that some of those American cases have gone into that I've been talking about. It's the best we've got, but it's all we've got. Apart from the other two, which go into it in even less detail, Smythe and Thomas also involved eBay. It was a purchase of an aeroplane over eBay. I wasn't aware you could do that, but apparently you can. And then the parties had a bit of an issue. The question was whether the contract was formed when it was purchased at the time of clicking on the purchase on eBay, or whether it was subject to a later inspection by the purchaser. And the court held that the contract was enforceable once the OK had been clicked on eBay. And a similar variation on the theme, the Centrebet case was a Northern Territory Supreme Court case about at what point in time an online contract comes into force, and again it was the same answer. So there's no dispute that if you click on OK, it's an effective way of entering into a contract, and that you'll be entering into the contract at the time you click on OK. That part is really not debatable, or shouldn't be debatable, in terms of when the parties' minds meet and get together and form a contract, offer an acceptance, which now we'll be discussing later on today, if you haven't already. It's the other cases, it's the cases where you don't go through that process that the issue arises. Now, Meyer and Kalanick, the Uber case, like I said before, this is not any more important than any of the other cases I've mentioned at the moment in terms of the scheme of things. It's just another judge's view on another set of facts. But we got this judge, Judge Rakoff, clearly on a bad hair day, and he hated this contract from the minute the judgment opens. This is on the first page of the judgment, and it sort of sets the scene. And just to paraphrase the quote that's there, it's hard to paraphrase it, but he says, consumers are routinely forced to waive their rights on the theory that they've voluntarily agreed to do so in response to endless, turgid, often impenetrable sets of terms and conditions, to which by pressing a button they've indicated their agreement. Then he goes on to pose questions in the second paragraph. What about where you're not asked to click on OK? What about where it's not made clear that when you click on OK you're actually agreeing to terms and conditions, which is the signing wrap scenario? What if the terms and conditions, or the directions to the terms and conditions, are printed in small type that's almost illegible? So he was out to kill this contract from page 1 of his judgment. And what he's saying is, and I sort of like his starting premise. He's saying enough is enough. We've got to actually sort of start applying some logic here rather than very simplistic legal rules that were great in 1906, but maybe they don't work all that well anymore. We found that the contract, this is an Uber user contract, and let me say at this point, I've never been in an Uber vehicle. I've never signed up to Uber. I don't know anything about the process in Australia, and I don't know whether it's the same in America. It doesn't really matter. The facts in these cases never matter. It's the principle that we're talking about. Anyway, he didn't like this case. He didn't like the contracting process, and therefore found the contract unenforceable for a number of reasons. In fact, just about every reason he could think of, all of which have been contentious in the earlier cases that I've talked about. He didn't like the fact that there was no I accept button to be clicked at all. That was his first point. And he described the process. The process involved, apparently, and maybe it's the same here and you'd all know, apparently on page 1 you click on to register, then you go to a next page where you enter and click on your financial details, and apparently at the bottom of that page, but not involving any clicking, were terms of service. So he said, you're behind the 8 ball from the start if you haven't got a CLICKWRAP arrangement to click on I accept the terms and conditions. Not fatal to the case, but he said that's a bad start. He also said, expressed cynicism, and this is apparent from the previous slide, about this voluntary surrender of rights. He said, we all complain about the younger generation these days. They don't care about their privacy. They click away all their rights on social media. Everyone just clicks on OK to everything. How irresponsible are the people who are doing the clicking? And he's saying, well, maybe the irresponsibility lies on the other side. Maybe it lies with the courts who say this is okay. And maybe it was okay back in the pen and paper days, but in an online world, do we really agree that everyone is happy to surrender their rights? Are they being put over a barrel and just forced to surrender whatever rights they may have, which they don't even know about? And is this really a good way to do business? He didn't like the cumbersome registration process that I've just described, where you had to go through a multi-step process of clicking, none of which clicking was relevant to the terms of service. And he said that what happens there is people get bored, they get frustrated, they just want to get the process over with, they just want to get in the taxi basically, or however it works. And he said that suppliers know this, everyone knows this, and they maybe we should ask ourselves, are they cynically preying on the fact that people haven't got time, effort or interest enough to read these terms? Is that a good way to do business? He acknowledged that there was a reference to a hyperlink containing the terms and conditions, but he was critical of the smaller font that was used, which he said was barely readable. And I suppose if it's barely readable for one judge, it might be totally unreadable for another type of person. Also, he didn't think the terminology was clear enough. Now, the terminology referred to, it said the terms of service appear below. Now, you remember in that Fatager and Facebook case, the court said any regular internet or Facebook user knows that terms of service means the same as terms of use. Let's not play funny games here. But in this instance, the judge said, in his opinion, a reference to terms of service appear here is actually potentially misleading for the average user. They might think it means Uber offers a whole lot of different range of services. Click here if you want to know more about the services we offer. He said it wasn't a logical connection to assume that terms of service meant these are conditions of use. And the other thing he didn't like was the excessive amount of scrolling. Now remember that very first case we looked at, Forrest and Verizon, back in 2001, the judge said 13 pages of scrolling, big deal. You know, you got the choice, you read it or you don't read it. It's like any other contract. The rules of contract hadn't changed. The terms are there, whether they're 1 page or 13 pages. You click OK, so be it. In this case, it was 9 pages, apparently, 9 pages of contract to become an Uber user. And he said, his quote was, even if the user were to arrive at the terms and conditions, so even if you found them, they consisted of 9 pages of highly legalistic language that no ordinary consumer could be expected to understand. So maybe any one of those factors mightn't have been fatal, but put all together, the judge said the contract is hopeless. Reading a bit more into that judgment, though, he's saying we really have been living in sort of, in a bit of a dream world for some time. Is it time that the whole legal community, the whole contracting community, the whole commercial community, the whole consumer community sort of had a closer look at how this works? Because we all know it's a fiction. Why do we perpetuate this fiction? That there are terms and conditions that we all know no one ever reads. Sorry, did you have a question?
Yeah, I was wondering if in this case, because it was relating to a binding arbitration clause, and that would be something that you may not expect to find in a terms of service, terms of use thing, and it was sort of precluding the jurisdiction of the courts, if that also weighed into the decision in this case to say, look, you really can't do that.
Well,
on page 7 of scrolling through it,
what you're saying is accurate to a point. Certainly was about arbitration. Almost all the cases I've mentioned have actually been about arbitration clauses. Sometimes, it depends, of course, whether it's the plaintiff or the defendant, but if it's the user, they're complaining about the fact that they wanted to enforce a right and they found they've waived that right in terms and conditions. But quite often the case is brought by the supplier who wants to enforce their arbitration clause in relation to a class action, so sort of a counterclaim, and that's because they want to activate the arbitration clause and the jurisdiction clause. They want to have every case heard in California in accordance with Delaware law. It's a normal combination. But yeah, that didn't help. I mean, if the terms had been innocuous, the case would never have probably become a case. So, but it takes something like the existence of an arbitration clause, or a particularly oppressive exclusion clause, or a really inconvenient choice of forum clause to get these cases to go as far as they do. So it's a fair point you raise. Now, that's where that case left us. Oh, gee, okay, I'm going to race through in two minutes. I'm going to tell you everything you need to know about the Australian consumer law. That would surprise some people, but just be thankful because it's terribly boring. But totally fundamental. Now, this is just something you've got to factor in. It doesn't change anything I've said in one sense, but it's an extra factor to factor into your thinking. I really will race through this in 2 minutes. The Australian consumer law contains a segment that deals with the concept of unfair terms in standard form contracts, and only applies where you've got a consumer contract or a small business contract. I'll leave it to Catherine to talk about that later on today if people are interested, only in the interest of time. But most contracts they're entering into online will fall into the category of a consumer contract or a small business contract. So just take it that box is ticked. So that being the situation, the question becomes, is it a standard form contract and is it an unfair term? If it is an unfair term, it won't be enforceable. An arbitration clause we've just been talking about wouldn't be an unfair term, but a total disclaimer of liability could well be. The onus is on a supplier to demonstrate that a contract is not a standard form contract. Whether or not it's a standard form contract will depend upon depends on the facts, but the court says in section 27, subsection 2, you take into account the bargaining power of the parties, the ability to accept or reject certain conditions, the ability to negotiate certain conditions. Obviously, by definition, an online contract is a standard form contract because you have no power to negotiate the terms. So we've ticked that box as well. The question then becomes, is a term in an online contract unfair? And there are a few criteria set out in section 24 that provide a guide as to whether a term is unfair or not. Essentially, it must cause a significant imbalance. It can't be something that's fair and reasonable from the supplier's point of view to protect their legitimate interests, and it's got to be capable of causing detriment to the other party if it's enforced. So if I just pick up on that arbitration example, if you're in Australia and it says all disputes must be submitted to arbitration in Victoria, that's not going to cause you any detriment, basically, so that's not going to be an unfair term. But if it says you can't sue us under any circumstances, as well as offending other provisions of the Australian consumer law, that may well be regarded as void. But it's not saying that all tough terms are void because they're unfair. It's not unfair if it's reasonable from the supplier's perspective. It may well be reasonable for the supplier to say there's a cap on how much you can sue us for example. And then the court says also, by way of sort of preliminary determination of what's an unfair contract, there's various things you've got to take into account, but including it's got to be a term, it's got to be transparent, or it runs the risk of being unfair, and it'll only be transparent if it's expressed in plain language, legible, presented clearly, and so on. So all of that sort of preliminary stuff. The point I want to get to is this slide, which says the court doesn't say what is or isn't an unfair term. It just says that these are examples. So the section says these are examples of what might be deemed to be unfair terms in a particular context, depending on the facts. Now, it's a big long list from A down to L, I think it is. I've just reproduced some of the ones there that are regular appearers in online terms and conditions for the sort of services you buy over the internet. A right to limit performance, to vary the contract, to vary the goods or services themselves. You often see that. If we don't have one of those available, we'll send you something that's reasonably similar. Ability to unilaterally interpret the terms. Now, if there's a dispute, we will, acting reasonably, we will tell you what we actually meant to say. Unilateral right of assignment. Limitations on right to sue. So liability caps up to a point, or after a point, can be unfair. These aren't determinative, they're just examples, they're signposts. What all of those means, and what all of this means, is that when you're looking at an online contract and trying to decide whether it's enforceable or not, it's not just a question of how the terms and conditions are brought to your attention, which is what all those American cases and those fundamental Australian pillars are all about. It's not just cases of that. In Australia, to be enforceable, the extra consideration to be taken into account is what's actually in those terms and whether they fall foul of the unfair contract terms and provisions. It's a bit of an aside to the point I've been trying to establish in this discussion, but it would be remiss of me not to say that that's part of the matrix. Catherine, I'm aware I've gone for my hour. I'm happy to answer questions. I'm happy to give people.
As long as you've got time to stay.
I've got to be somewhere by 12.
So, Well, I asked that before I asked whether there are questions.
Oh, no, I'm very happy to
comments,
take questions.
frustrations, observations.
Thank you very much for that. It's quite interesting. I think one of my
It's
biggest.
very interesting.
Yeah, it is a very interesting space.
It's a hard
I
man.
think with the Australian context, I guess, I think consumer laws are quite different in the software terms piece. How does it interact with jurisdictional issues when we've got international companies operating in Australia or selling products in Australia without an Australian presence?
Yeah. There's a case of Valve Corporation, which you can look up. I can't remember the entire case, but if you Google it, you'll find it, which talked about that very issue. The simple answer is that it's acceptable for the governing law of the contract to be an overseas jurisdiction, if that's, for example, where the supplier is based. Nothing wrong with that. That's the old principles of the proper law of the contract. But you can't, just by stipulating that it's governed by the law of California, avoid the operation of the Australian consumer law if there is an Australian connection involved. So if the goods are being purchased in Australia by a consumer in Australia, the Australian consumer law will apply. So you effectively then become subject to two sets of laws. But that's a very good point. One that's vexed lawyers for a long time until the Federal Court handed down this decision in Valve Corporation about 12 months ago. It's a good case to read.
And is that sort of similarly applied where they have a term which says you can only bring action to us, like a choice of forum kind of term?
Yeah.
You know, it's a bit much to expect one person to go to America and sue Apple or something.
Well, you can have a situation where a choice of law clause is unenforceable contractually because it's unreasonable, but if you've got parties in two jurisdictions, the court will generally say, so long as there's a connection with one of the parties, that's enforceable. That's what a lot of those class actions are all about, is that they were enforceable in America. But if you've got a complaint under the Australian consumer law, which is actually not part of the contract, but it's local laws being superimposed on a contract governed by overseas law, then you could bring that case in the federal court in Australia. And no one has to ask another question because I'm very happy to go. It's very sunny outside.
So on behalf of the class, we would like to thank you so much for coming and sharing your thoughts on this very important legal issues that will, for me especially, will help me to interact with online contracts from now on. So thank you so much.
Thank you.